Okay, today is Tuesday, March 26, 2013. I want to make a notation for myself for trial. The fact that they didn't follow contractual procedures, that's one thing. Disciplinary action was denied, that was another thing, and they should have put me back to work like 1,500 Teamsters. I believe the reason they didn't put me back to work is because they don't deal with disability issues. I think that's what it is, because I sent up a prescription and the test results for hearing impairment. So they were aware of the fact that I have a hearing impairment, and they denied me arbitration. Because the union probably, the company, Safeway, doesn't want to put me to work because I have a disability. And they probably going to deal with it in workman's comp. So the union just went along with Safeway. But the fact is, the union doesn't realize, I believe, that the Disability Act of 2009 was amended, and it included unions. There are no laws that discriminate against people that have a hearing impairment. And I'm stating for the record that they did. They discriminated against me by not returning me to work like 1,500 other Teamsters, that it was not filed in a timely manner, that it returned to work immediately. Now, the fact that the union doesn't handle disability issues is incorrect. According to the Disability Act that was amended in 2009, which includes unions on the hearing impaired. So I'm sitting here waiting for a phone call or registered mail, and it hasn't been done due to the fact that James Williams, the transportation manager, didn't fulfill his responsibilities. So I'm saying that he knew all what's going on, and he refused to comply with the Disability Act of 2009. So that's my statement for trial, and I believe that's what the problem is. The union will not deal with the hearing impaired, and Safeway will not put me to work because I have a disability, and the union is incorrect because they violated their contract by not working me first and grieve later and let these issues be resolved in a time. And the fact that Mike Teller didn't file in a timely manner also shows that the fact that they don't want to put me to work because of my disability, and they don't want to honor the notice of offer of work, which is good for 1 year, and it needs to be enforced. So I'm stating for the record that Local 439 Teamsters in Stockton, California violated the Disability Act that was amended in 2009 for the hearing impaired, and that they're well aware of the issues, and they denied me arbitration. And when they did that, they violated the Disability Act of 2009 that was enacted by the United States Congress. So that's my statement. Okay, I'm just going to add this to the end of that recording. I'd like to remind the court the fact that when I was sent home on December 7, 2010, when I received the QME report on December 1st, 2010, it wasn't complete. The QME report was not complete because the doctor, I forgot his name, said that he doesn't do hearing tests. And I received that on December 1st, 2010. Like I said, a short story. I don't want to make a long story of it. Short story. The fact is that the QME report wasn't complete. They offered me work for 1 year, and I needed it enforced because the QME report wasn't finished yet. They just flat out sent me home, and I'm sitting here, and I don't know why I'm sitting here. They violated all the time limits. They didn't produce any evidence of what my disciplinary action is to be or what it was by December 25th, and at least they had to put something in by December 28th. within 10 days. They didn't do so. They didn't do anything. They went around the Board of Adjustments, and that has time limits within 30 days. They didn't do that. They just didn't do anything within the time limits. And I don't know why I'm sitting here waiting for a phone call or registered mail to report to work when I have 200 employees underneath me. Now, James Williams, the transportation manager in Tracy, California, knows all this. He should have returned me to work like he does for 1,500 other Teamsters or 400 truck drivers. If it's not within the time limits, they're returned to work immediately. If it's not within the time limits, they're returned to work immediately. Now, I should note for the record, and Administrative Judge Grill, the fact that I don't know why I'm sitting here. They didn't produce anything. I never received any registered mail whatsoever of any suspension or discharge within the time limits. I did not receive one document of why I'm sitting here waiting for a phone call or registered mail to return to work according to the notice of offer of work that I asked for Eureka Run at 10 o'clock in the morning. And I'm still sitting here waiting. So I should get all that back pay because they didn't comply. 3 times they didn't comply. And I hate to keep repeating myself, but my life is on the line here. And I don't know why I'm sitting here. I don't have one document. Not one document for suspension or discharge, or the reason why I'm sitting here by registered mail within the time limits. Not one. And I'm still sitting here. So I should get all that back pay and benefits, and I hope Administrative Judge Grill returns me to work according to the notice of offer of work that wasn't complete. They just flat out sent me home. And so I'm not going to go into it anymore about the deposition that I wasn't accommodated or anything else, and I need to take another deposition for the record. And that I have a new attorney, Modesto Legal Clinic, who took my case. Obviously, by my statement, you know why. The fact that Judge Grill didn't have nothing on the table, not my severe profound hearing impairment or the notice of offer of work. And that if it's at all possible, if Judge Grill could agree to the fact that Safeway should pay all attorney fees and expenses to Modesto Legal Clinic for all their hard work and getting me to be returned to work. For the fact that Adam Stewart, I feel that he failed in his responsibility by not getting me a hearing test or not mentioning the fact to the Administrative Judge Grill that the QME report was not complete. And I didn't get paid every week or every 2 weeks. And that they're in conflict of liability with the EDD, Department of Unemployment. And he didn't mention one word about it since 4/17/2009 and ongoing. And I received another document from EDD saying that Safeway is in conflict of liability. I should be working. So with that being said, and the fact that Safeway doesn't want to comply, and it's just more time and money for Modesto Legal Clinic, who's representing me. And I don't feel I should have to pay Adam Stewart anything. So, but that's for you to decide what is fair and equal under the law. And your decision, I agreed to accept your decision, whatever is reasonable under the law. But I do request to go to trial to hear the case for the 202 Disability Act of 2009. Anyways, like I said, I have permission, or I was instructed to pursue this by the union attorney on Workmen's Comp, and they're aware that I have a disability issues. I exhausted the union remedy. There's no remedy under the union to return me to work because I have a disability. And so they're not going to deal with it, and they threw it on Workmen's Comp's lap. So, and the fact that I told them that I had a severe profound hearing impairment, and that wasn't acceptable, even though I sent them a prescription and the test results to the union attorney, and it wasn't accepted, and they denied me arbitration. And so I, Julio Zamora, invoke double standards. Life is not fair. Okay, today is Friday, March 1st. Making a statement for Judge Grill Settlement Conference in Stockton, California. On 3/21/2009, I was injured on the job, and I went to see Nancy Perdillo, and she stated that it was a sprain. I don't recall going to the hospital or an MRI being taken at that time. And she's an alcohol and drug technician, which gives you tests to see if you were on drugs or alcohol at the time of injury. And there was no doctor present. On maybe a week or 2 weeks later, I ended up in the Los Angeles Memorial Hospital with severe pain. It was really, really bad. I couldn't take it anymore. So I was there all night long, and they took an MRI and discovered the fact that I had a pinched nerve. They took an MRI the next day. I went in there for left leg pain, the same thing I'd seen Nancy Perdillo for in Tracy, California. Drug and alcohol technician who said it was a sprain. Now, I'm not going to go into the PR2 report because it's incorrect and it wasn't completely signed properly. And the fact is I had a treating physician that I signed for good for 1 year, Paralosi, chiropractor. That if I get hurt on the job, that I'm to go to the company doctor for 30 days and then the chiropractor is to take over. Okay, so and the Los Angeles Memorial Hospital made out an occupational report stating the fact that I went in there for left leg pain and that I have a low back, a pinched nerve. And I don't remember who I got the referral from, if it's Los Angeles Memorial Hospital, what doctor it was, or if it was Dr. Yip or Paralosi. But they gave me a referral to Dr. Baby, and to fix the pinched nerve, it's a walk-in and walk-out type deal. And I was denied by Safeway, and they sent the letter to the wrong person, to Dr. Hubby, asking her if it was job-related, the pinched nerve. And they should have sent it to Nancy Perdillo, the drug and alcohol technician, but they didn't do so because she's the one that said it was a sprain. So, okay, I haven't been paid every week or every 2 weeks. Disability payments since I would say since 3/21/2009 or 4/17/2009. I had to file for unemployment, and they sent me a letter stating that Safeway was in conflict of liability, and they sent me another one in 2012 or 2013 that Safeway is in conflict of liability. I should note that I have a notice of offer of work that I received on December 1st. December 3rd, I went to work. On December 7, 2010, they flat out sent me home. Just flat out sent me home. I had no representation. And the fact is, I was supposed to work first and leave later. That didn't happen. They just flat out sent me home. And they made false accusations. And this is all disability related due to the fact that I filed in 2009 severe and profound hearing impairment from reefer noise. Come to find out at the settlement conference, Judge Grill's court suggested that I get a legal document for severe and profound hearing impairment, and come to find out that I've had a hearing problem since 2006. I needed to be accommodated with a listening device because I have more than a 50% hearing loss in both ears. And I should note also for the record, since 2006, I have never been accommodated with any sort of listening device or hearing aids or anything else for that matter. It wasn't taken serious by the union or the company. But due to the fact that they had a panel hearing and they flat out sent me home when I mentioned the fact that I had a severe profound hearing impairment, and I asked the shop steward, are you an authority on severe profound hearing impairment? And Mr. Nicewanger, the BA from Local 439 Teamsters in Stockton, California, which is a union shop, was there also, plus another shop steward was there when I made that statement. And he said he's going to look into it, and they just flat out sent me home and didn't accommodate me. And I should also note the fact that they didn't, Safeway didn't follow contractual procedures. I was denied to return to work because they didn't comply with the time limits, like they do for 1,500 other Teamsters, or return to work immediately if they violate the time limits. They didn't do so. I should also note that they're required to go to Board of Adjustments for all suspension and discharges within 30 days. I should note that on December 17, 2010, Mr. Nicewanger sent a letter to the terminal manager, James Williams, that all disciplinary action to be denied, and to send all proof, photos, evidence, whatever you have by December 25th, to establish a fact beyond a reasonable doubt that Mr. Zamora did wrong or deserved disciplinary actions, and to set a time and date. Well, the terminal manager, James Williams, did not comply. He set a date for January 11, 2011. I should note that's not within 30 days, according to the contract. All Board of Adjustment suspension and discharges are to be heard within 30 days of date of incident. And they didn't comply with time limits or anything else for the record. And on top of that, I was never notified that I was ever discharged by registered mail. I was never notified that I was ever fired, discharged, or suspended by registered mail, according to time limits. Okay? And so going from there, they didn't honor the notice of offer of work. They didn't apply, even though they made an agreement with Workmen's Comp to work me for 1 year. And it was deemed accepted, whether I turned it in or not, and I had 20 days to comply or think it over if I wanted to change in job or retire, etc., etc. Well, I asked for Eureka Run 10 o'clock in the morning bid, and that I was hired in 2002, and that I had 200 employees underneath me, and there was work available, and that anybody who works underneath me, I get paid for that day, and it's a 24-hour operation, 24 hours a day, and there's 400 truck drivers there. And I should note that I've been waiting for a phone call or registered mail to return to work, in which they are not complying with the notice of offer of work, and they're not completing their agreement that they made. In other words, they're in violation of their own agreement. So I needed to be enforced by Judge Grill in the settlement conference. I'm waiting for a court date from Modesto Legal Clinic because we were waiting for a document to get a legal document stating that I have a severe profound hearing impairment, which states that I had a hearing problem since 2006. And they haven't accommodated me with any listening device or whatsoever since 2006. Okay? So on December 7, 2010, they just flat out sent me home, and they didn't pay me for the day. And I wasn't represented by the union on interrogation by the dispatcher. He told me the shop steward is on his way, and he told me to sit down. And I was supposed to work first and grieve later. It didn't happen. And they just flat out sent me home. Again, I hate to repeat myself, but I have a severe profound hearing impairment. The panel hearing was put in abyss. And I told them, are you an authority on severe profound hearing impairment? And they just flat out sent me home. I had a settlement conference, and Judge Grill was off that day, and Adam Stewart was my attorney, workman comp attorney at the time. The administrative judge suggested that they put me back to work due to the fact that the Safeway attorney was on the phone with Safeway, and Adam Stewart approached me, and my wife was there and asked me how long I could work for. And I thought that was peculiar because I had a notice of offer of work guaranteed or work for 1 year, which they didn't comply to. So that was the second time. The first time they violated the time limits in the contract, and they didn't put me back to work like they did for 1,500 other Teamsters. The second time was the administrative judge suggesting that they put me to work, and the Safeway attorney must have told Adam Stewart, I don't know, because when he asked me how long I could work for, and he left, a lady or a secretary came up to us and told us to go to the lunchroom, and then later told us to go home. So that was the second time. The third time, Miss or Mrs. MORLES, Safeway Private Insurance from Arizona, sent me a letter, or sent my attorney a letter, honoring the notice of offer of work, suggesting that I should sign it and send it to Arizona, which I did registered mail in 2013. My attorney, Modesto Legal Clinic, sent me a letter to report to work immediately. I did so. Safeway and the union did not comply, or the union didn't take any action, and even though that they were aware of, or I made them aware of, that I had a severe profound hearing impairment to their attorney, and I also sent them a copy of a document of an examination showing and stating with a prescription that I had a severe profound hearing impairment, and they ignored it. In fact, I asked for arbitration, and the union attorney denied it, but suggested or mentioned the fact that we know you have a disability issue, and that arbitration is refused, and that you could pursue it under workman's comp if you wish to do so. At that point, I figured I exhausted the union system, whatever it is. I exhausted it, and now it's in workman's comp's lap. So at that point, they didn't comply. They put it on workman's comp to comply, so I'm asking workman's comp to enforce the notice of offer of work. And I'm asking for trial, because I'm assuming the fact that they're in violation of 2009 Discrimination Act against severe profound hearing impairment or people with hearing impairment, and that the union did not comply with federal law. So I could be wrong or I could be right, I don't know. So, but I'm asking to go to trial so that the judge can make a decision on that, for the fact that I've been sitting at home waiting for a phone call or registered mail to report to work since December 7, 2010, and I need a court order to get all back pay and benefits 7 days a week, 14 hours a day, plus my lifetime medical to be restored, medical, prescription drug, Delta dental, eyeglasses, and I don't know about hearing impairment, and then I'm at 90%, so I don't know what the court wants to do about that, but I'm asking for it to be reinstated. Due to the fact that all disciplinary action was denied on December 17, 2010, because the grievance was received by Teamster Local 439, Mr. Nicewanger, on December 17. It was stamped received Local 439 on December 17, 2010. That's more than 10 days. And I should note they didn't respond in 10 days on December 25th, 2010, when they were required to do so according to contractual procedures, and they violated the time limits and also Step 1 and Step 2 of the contract, in which they didn't comply, and the union didn't enforce contractual procedures, let alone a hearing device, or assisted hearing device at the panel hearing, and they put it in a biz and sent me home. So I'm asking to go to trial for the court to get a court order for back pay and benefits and automatic retirement on my birthday on September 7, 2013. And that everything to be restored, back pay and benefits and pension and RSVP. I don't make any any payments. It's a premium, lifetime medical. I need that reinstated, and I don't make no premium payments after I retire. None. And I need that reinstated or made whole again, including my pension, my back pay, and health and welfare to be paid. Because my wife is sick and she ended up in the hospital, and it's it's really hard. I have to pay for that bill. So if they could pay for the health and welfare for the year of 2013, I would appreciate it, and then I wouldn't have to make payment to the hospital. And the union put it on Workmen's Comp to resolve these issues. They said I could pursue it under Workmen's Comp, so that's why I'm bringing all that up in the union matter. I'm bringing it up for the fact that they didn't deal with the issues of severe profound hearing impairment, and the fact they didn't deal with the issue, the fact that the dispatcher on December 6, 2010 changed the time on my logs from 10:30 to 11:15, taking the time from the second time clock. I should note that it put me in violation of Department of Transportation and company policy. And he accused me on December 7, 2010 of falsifying documents or intent to falsify documents that he altered or falsified on December 6, 2010. And I should also note that the onboard automatic recording device in the tractor is tamper-proof. Tamper-proof. And you also have to have a key in order to change anything. And the dispatcher is the only one with the key. I'm assuming that's correct because I've seen them change the time on logs before or corrected them, whatever the case is. I don't know what authority they have on changing logs. Under the Department of Transportation 395.15, 395.16, and the interpretation in 395.8, it states in there that they're not allowed to alter or change anything on them logs. If there's a problem, there's a write in the remark section what the problem is. And what the problem is, and make the driver aware. They didn't do so on December 7, 2010. And so I should note for the record that they didn't honor the notice of offer of work at least 3 times. They denied to put me back to work. And that I have a permanent disability according to the QME report. And that it states in there that I could do my customary duties on my job. And I should also note that according to the legal document that I have that was requested by Judge Grill in the settlement conference to 2 attorneys that I just received, that I have a severe profound hearing impairment since 2006, and that I lip read. I'm not good at it yet, but I'm learning, and I'm also trying to learn sign language. But the point is, I've never been accommodated at any time since 2006, and they need to accommodate me with hearing aids because I bought my own, and they're old, and they don't work at all. And I need something that blocks out background noise and stuff like that from the reaper. So again, I'm asking for a court order to be returned to work, all back pay and benefits, and health and welfare, and my lifetime medical, according to the 2009 Disability Act, and also to the contract, okay? Because I didn't do nothing wrong on December 7, 2010. The only thing I received was a notice of offer of work, and they just flat out sent me home, and I was also on FMLA. So this is my request for trial, for Judge Grill to consider sending this case to trial to resolve the issues of the Disability Act of 2009, hearing impairment. I would appreciate it if we did that, and I also would appreciate the fact that he enforced the notice of offer of work and return me to work according to the contract. And I would appreciate that. And I should point out that the fact is that they've been refusing me, denying me medical treatments. I don't get paid every week or every 2 weeks since 3/21/2009 or 4/17/2009. They refuse me to put me back to work when I have a full duty release to go to work. They won't accommodate me with hearing aids. They won't honor the notice of off for work. I hate to keep repeating myself, but I do have a severe profound hearing impairment, and my life is on the line. And I need the notice of off from work to be enforced for the fact that my daughter needs 1 more year at the university to get her BA in biology. 1 more year. I need that 1 more year. And they made an agreement with Workmen's Comp to work me that 1 year. And I'm asking for it to be enforced so that my daughter can finish at the university. And that was a guarantee for 1 year. And I didn't start 1 day on the 10 o'clock shift Eureka run. So I'm asking Judge Grill to consider that. And I'm also asking him to consider the fact that a double standard is the application of different sets of principles for familiar situations, or 2 different people in the same situation. A double standard may take the form of an instance in which certain concepts, often, for example, a word, phrase, social norm, or rule, are perceived as acceptable to be applied by one group of people, but are considered unacceptable, taboo, when applied by another group. The concept of double standard has long been applied, as early as 1872, to different moral structures on men versus women. A double standard, thus, can be described as a sort of biased, morally unfair suspension towards a certain group of the principle that all are equal in their freedoms. Such double standards are seen as unjustified because they violate a basic maxim of modern legal jurisprudence that all parties should stand equal before the law. Double standards also violate the principle of justice, known as impartiality, which is based on the assumption that the same standard should be applied to all people, without regard to subjective bias or favoritism, based on social class, rank, ethnicity, gender, religion, sexual orientation, age, or other distinctions. A double standard violates this principle by holding different people accountable according to different standards. The phrase "life is not fair" may be invoked in order to mollify concerns over double standards. I'm hoping that Judge Gill considers this statement for the fact that if the company doesn't comply with the time limits under the contract, 1,500 Teamsters are returned to work immediately. Well, they didn't put me back to work. And James Williams, our transportation manager, knows all this. He knows everything. He knows what's going on. But he didn't comply. He didn't put me to work, back to work like they do for 1,500 Teamsters or 400 truck drivers. I should note that for the record. And I should also note for the record that they didn't accommodate me with any listening device whatsoever since 2006. So I'm asking Judge Grill to consider this and to enforce a notice of offer of work because my life is on the line here and I have no lifetime medical, I have no medical coverage whatsoever, even though I paid for it in 2002. I paid $3,000 plus to cover for 5 years so that I could retire at any time. And I should also note to the fact that Safeway called the health and welfare and said I didn't work at Safeway. And that barred me from getting any kind of lifetime medical or asking them to keep me covered. That didn't happen. So, and the fact that the dispatcher who falsified my log by taking the time off the second time clock, and they have a no-fault attendance policy, and they applied it to everybody else, but they didn't apply it to me. No-fault attendance policy that's been as part of the company policy for 10 years that I've been there, and from my understanding, it's been on there for at least 20 years. No-fault attendance policy. So, and the fact that I never received any registered mail or anything else stating that I didn't work at Safeway at any time, not within the time limits. Okay? So, and the fact, that they just flat out sent me home. And they didn't pay me on December 7, 2010. He took my time card or my trip sheet or whatever it is and disposed of it. I don't know where it went. It disappeared. And I never got paid for that day. So that's why I'm asking for back pay from December 7, 2010. And I hope Judge Bill considers again to enforce a notice of offer of work and that to send this case to trial. Now we hope he considers this seriously for the fact that I have a hearing impairment and that the union should be held responsible under the Disability Act of 2009. And that's my statement for the court. So I hope Judge Bell considers the double standards.